All rise.
Kosovo Specialist Chambers is now in session.
Please be seated.
Good morning, everyone, in and outside the courtroom. Madam Court Officer, can you please call the case?
Morning, Your Honor. This is case KSC BC 2020-05, the Specialist Prosecutor versus Salih Mustafa.
Thank you, Madam Court Officer. Now I would kindly ask the parties to introduce themselves, starting with the Specialist Prosecutor.
Good morning, Your Honor. Good morning, everyone. The prosecution team is represented today by Alex Waring, the Deputy Specialist Prosecutor, myself, Cezary Michalczuk, SPO Prosecutor, Filippo De Minitis, Associate SPO Prosecutor, Silvia Diascoli, Associate SPO Prosecutor, and also Line Pedersen, Case and Evidence Manager. Thank you.
Thank you, Mr. Prosecutor. Now I turn to the defense, please.
Thank you very much, Martin. Good morning. The defense is represented by myself, Julius von Monet, lead counsel. The accused is not present and has given notice of that. And remotely, I think, are watching some members of my team, Betim Shala, co-counsel, and Fatmi Belay, he is an investigator. And there is another gentleman, Afdi Mehmeti. He will join also later on the defense team when the paperwork is finished. Thank you very much, Your Honor, for this moment.
Thank you for this, Mr. von Bonnet. I note for the record that they are not present in the courtroom, not remotely, but they are just watching, according to what you said, Mr. von Bonnet. And for the record, I am Nicholas Guillou, pretrial judge for this case. On 17th February, I scheduled the 5th status conference for this case. My objective today is to review the status of the case and to organize the last procedural steps before transmission of the case to the trial panel. I see that no written submissions were filed by either of the parties. I'll ask the parties for their submissions in turn, according to the scheduling order, first on disclosure, then on investigations, and then on the calendar for the remainder of the pretrial proceedings. As usual, I remind the parties to give prior notice should any submission require the disclosure of confidential information so that we can go into private or closed session. However, before we start with the first item on the agenda, I would like to thank the parties for their joint submissions on the lesser redacted version of the transcript of the third status conference filed on 15 February 2029, which is filing F79. Accordingly, I will issue the following oral order. The registrar shall prepare a lesser redacted version of the transcript of the third status conference held on 14 December 2020. Redactions shall be kept only for the following segment: lines 11-12 at page 97, lines 17 to 23 at page 100, lines 19 to 25 at page 101, lines 1 to 11 and 18 to 25 at page 102, and lines 11 to 19 at page 103. All other redactions shall be lifted. I would now like to move to private session briefly to discuss with the parties about a very recent filing. Madam Court Officer, please let me know when we are in private session.
Your Honor, we are back in public session.
Thank you, Madam Court Officer. And the last point before we start with our agenda, I would like to ask the prosecutor whether he and when he intends to file a public redacted version of its pretrial brief.
Your Honor, for the time being, and for reasons that also may concern the protection of witnesses and victims, the prosecution was not planning on filing a public version right now. But if Your Honor wishes us to do so, we will do so as soon as practicable.
Thank you, Mr. Prosecutor. Mr. Fonboni, do you want to say anything on this?
I have no objections against a non-public filing, so to speak. If the prosecutor wishes to do so, they can proceed with that. The defense have no objection with that.
Thank you, Mr. Fonboni. Now let me move to the first topic on the agenda, namely whether the SPO has completed disclosure of evidentiary material, including exculpatory evidence, and if not, the amounts of items that remained outstanding, under which rules the items to be disclosed fall, by when the SPO intends to disclose such material, what are the reasons for this late disclosure, and whether protective measures are required, and for how many witnesses. I also invite the prosecution to indicate whether the SPO still has any exculpatory evidence in its custody, control, or actual knowledge that must be disclosed to the defense pursuant to Rule 103. Mr. Prosecutor, you have the floor.
Thank you, Your Honor. Your Honor, the SPO has completed its evidence disclosure and does not foresee the need for additional disclosure of evidence, with the exception of evidence that may stem from the investigative activity that we informed Your Honor about this morning through the ex parte filing. With regard to exculpatory evidence, Your Honor, yesterday we disclosed to the defense, as per Your Honor's decision of 1st March of this year, the material included in Annex 1 of our 15 February request for reductions and delayed disclosure. Now, Annex 2 of that request concerned materials for which Your Honor has authorized delayed disclosure, and so authorizes the prosecution to withhold that material until a certain time. And that, Your Honor, is the only Rule 103 material that the prosecution is yet to disclose. With the exception of that, the prosecution has completed its obligation with regard to exculpatory evidence in its possession or knowledge. Of course, mindful of its continuing obligation in that regard, we will continue to review our records, and as well as new evidence coming in from investigation across the cases, and should any exculpatory evidence be arise, we will inform the defense and disclose it without delay. That is all, Your Honor.
Thank you, Mr. Prosecutor. Mr. Fonboni.
I take it that the prosecutor is talking about disclosure 35, which was which came in yesterday. Yes.
Mr. Prosecutor.
Yes, Mr. Bombonnet.
Yes. So there is nothing else that is coming, or is there still something coming?
Well, not for the time being. No,
Yes.
no. As I said, not for now.
No.
There may be in relation of that to that investigative activity that we've discussed earlier. And there is some Rule 103 documents that the pretrial judge has authorized us to disclose at a later stage.
Right. I understand. No problems. And no remarks, Your Honor.
Mr. Fonboni, any other general remarks on disclosure or any difficulties that you faced on that topic?
No, Your Honor.
Thank you, Mr. Fonboni. I now turn back to the prosecution for the second item on the agenda, which is the status of its ongoing investigations. In particular, I would like the SPO to indicate whether its outstanding investigative steps have been completed or whether an estimated date of completion can be provided. Mr. Prosecutor.
Your Honor, thank you. The SPO has completed its investigations. There are only two residual investigative activities. We discussed one of them during our during the private session, and we also made a filing this morning in this regard. So Your Honor is fully briefed about the item I'm referring to right now. There is another one, the second one, again, the residual investigative activity. Your Honor knows also exactly about this because we also made a few filings in the past with regard to this. These two activities will not hamper, they will not have any adverse impact on our readiness to go to trial, which is now. We are trial ready as I speak. At the last status conference, we also indicated that because of other investigations and other cases that we have where we still conduct some investigative activities, some material could also be discovered there that has impact on this case or is relevant for this particular case. But if such material is discovered at any point, we will fully and quickly comply with our disclosure obligations, and again, these will not also have any adverse impact on our readiness for trial. Thank you, Your Honor.
Thank you, Mr. Prosecutor. Now I turn to the defense. Mr. Fonbonnet, can you give an update on your investigations? In particular, I would like the defense to indicate an estimated date of completion, first on the defense of alibi, and then on the remainder of the defense investigations. You have the floor. Microphone, please, Mr. Fonbonnet.
Yes, Your Honor, the defense have seen, obviously, the tentative calendar that the judge made, and we seek at this point a little bit relief. The reason for that is actually that the 6th of April, which is now the deadline for the notification of the alibi, I think that falls nearly in the middle of a mission in which we are establishing that alibi, and I would like to actually notify the SPO when that is more or less nearly complete. In fact, I believe that in that month we will have most probably some other alibi witnesses, and I would like to make it as complete as possible in the pre-trial brief, that is. So the deadline, as it stands for now, the 6th of April, which would be just after Easter, if I'm well informed, that would be a little difficult for the defense to meet. Now, that being said, there is another deadline which is on the 18th of March, which is a request for protective measures. As it stands now, as it stands of today, I do not believe that we would in fact seek protective measures, but I cannot foresee what will happen in that mission, because that's going to be the longest mission of us. So if that we extend it, for example, to any other date previous to the deadline for the pre-trial brief. If it would be up to me, Your Honor, I would like to request the, it stands now for the 16th of April, the pre-trial brief, if that would be able to move to the 30th. I have seen that the 30th, you would like to transmit the file to the panel. However, I think that in that month we will more or less be able to complete most of it. So that is the reason why I think for the efficiency of the case and the completeness of the pretrial brief, that would be very useful to have that extension. As for the status conference afterwards, I think it would be then early May or something like that would be useful. Probably other team members will be also able to attend that session, including my client, and then you have a complete picture of everything, and then we can more or less treat residual matters as if they would occur. So basically what we would like to ask is the deadline of the notification, which stands for the 6th of April. That is a little bit too soon. That could be either the 16th of April, for example, or falling on the same time, more or less, as the filing of the pre-trial brief, so that we have it complete for that matter. But that's up to this discussion. For as far as I'm concerned, it would move about 2 weeks, and I hope that would be possible, so that it gives basically the defense the possibility to use the month of April and the month of March, because my next mission is about to start, not this week, but next week. So then we can get to a conclusion, more or less, of it. So obviously, I know that the pretrial brief can be amended, and also some witnesses can be added. But as it looks now, some of our witnesses were simply unavailable and are available in a particular time frame. So therefore, that would be useful to move it a little bit. That is what we seek, Your Honor.
Thank you, Mr. Van Bonny. Can you give me the date of your next mission to Kosovo?
Yes, it's tentatively the 19th of March up to the 5th of April. So that's why the 6th of April is such a struggle to make it. And if I end on the 5th of April, then I will just need a little bit take of time and see whether we need to seek protective measures. I do not, as it stands now, foresee it, but I cannot exclude it either. So that is why I seek a little bit of delay on that matter. And then afterwards, on the 5th of April, my next mission will be probably from the 16th until the 23rd of April, in that time frame. So that will then, we try to finalize in that with the team together, the people that we seek, both for alibi and non-alibi witnesses, which we would like to include in the pre-trial brief. That is basically how it stands as of today, Your Honor.
Do you think you can finalize your investigative activity related to the alibi defense during your first next mission?
That is absolutely the priority. Yes, absolutely. And the non-alibi witnesses, so that's why it's also a little bit longer. I must say that there is most probably also an alibi witness abroad, living not in Kosovo, so that that will probably then either be done in the third mission or not at all. It just depends how that is going to work out. But we will continue, obviously, a little bit with the witnesses, but the priority of it certainly is within that time frame. That's why the mission will take about 2 weeks.
Thank you, Mr. Van Bonny. This leads me to actually the next item in our agenda, which is the calendar for the pretrial stage. As you recalled, Mr. Van Bonny, I proposed a calendar for the last procedural steps of the pretrial proceedings, taking into account that the SPO has now filed its pretrial brief, its witness list, and its exhibit list, and that the defense has now is in the process of completing its investigations in the following weeks. I would like to ask the parties their views on the calendar. Mr. Van Bonny, you already mentioned a couple of requests. And in particular, I'd like the parties to comment on the following dates that were in my scheduling order. Thursday, 18 March, as a deadline for the defense to seize the pretrial judge with any requests for protective measures prior to disclosing alibi-related material. 6th of April 2021 as the limit for the defense to notify the SPO of its alibi and to disclose any relevant related material pursuant to Rule 104(1)(a) of the rules. 6th April 2021 as the proposed deadline for the defense to file any requests for protective measures for non-alibi witnesses. Friday, 16 April 2021 as the proposed date for the defense to file its pretrial brief and related material under Rule 95(5) of the rules without prejudice to subsequent amendments thereof, and to transmit the case to the trial panel on or around Friday, 30th April 2021, depending on the need for the parties to raise any residual matters they deem appropriate, and on the pretrial judge to rule on any outstanding issues, including the reclassification of filings and transcripts. So this is the proposed calendar. Mr. Van Bonny, you just mentioned already a couple of dates that you would like to be moved from this tentative calendar. I'll first give the floor to the prosecution to comment on this agenda, please. Taking into account what Mr. Van Bonny already mentioned in his proposals. Mr. Prosecutor, please.
Thank you, Your Honor. Your Honor, as just recalled by Your Honor, the prosecution has filed its pretrial brief, witness list, exhibit list, and Rule 109 chart, and so the prosecution is ready to move to trial. The prosecution has no objection to an adjustment of the calendar to accommodate the defense's needs for investigations. However, the prosecution would like to keep the 30th of April or shortly thereafter as a date that we should strive for to forward the case file to the trial chamber, either on the 30th of April or as soon as practicable shortly thereafter. So we have no objection, and we leave it to Your Honor to decide, keeping that in mind.
Thank you, Mr. Prosecutor. Mr. Van Bonny, let me go back to each deadline, so that is probably going to be clearer. For the deadline for when you will be ordered to notify the SPO of the alibi that you mentioned, I proposed Tuesday, 6th of April. What would be a date that would be possible according to your investigations, knowing that you will come back from Kosovo on the 5th?
So, Your Honor, I think, for example, the 16th or the 23rd of April for the notification, preferably the 23rd, and for the pretrial brief, the 30th of April. Currently, the pretrial brief is being set for the 16th. Currently, the notification is set for the 6th. So if it would be the 23rd, and if there would be any kind of protective measures, then 1 week earlier I could raise that. For example, the 16th, I could seize that opportunity to seek, because most of it, well, I think most of it will be done on the the 5th, so we will have an evaluation of which people seek protective measures. I do not foresee it as far as the alibi concern, but we just want to be able to conclude that carefully, and therefore the 23rd for the notification would be the best date. It would move it about 2 weeks.
Thank you, Mr. Van Bonnet. And you mentioned that at this stage you don't foresee any request for protective measures, correct?
That's right.
And this is true both for alibi-related witnesses and non-alibi-related witnesses, correct?
That is correct.
Thank you, Mr. Van Bonnet. Mr. Prosecutor, do you want to comment on this?
Yes, Your Honor. We have a preference for the alibi defense deadline to be set for the 16th of April. Also because we understand Council will finish its mission at the beginning of April, so we believe that leaves enough time to meet that 16th of April deadline. Thank you.
Yes, it's not
Mr.
only
Van
the
Bonnet?
witnesses, it's obviously also the material that we will try to put together. So obviously that 5th I have a good idea about the witnesses, and it's really day by day in the last mission. It's really every day. We didn't skip any day at all, so that would give a little bit of relief.
Thank you, Mr. Van Bonnet. Does any of the party wish to add anything on this topic of the calendar? No? Mr. Van Bonnet? At this point, I would like to ask the parties whether they have any other issues that they would like to raise. And as usual, I remind the parties to give prior notice should any submission require the disclosure of confidential information so that we can go into private or closed session. Mr. Prosecutor.
Thank you, Your Honor. No, Your Honor, we don't have any further matter to discuss.
Mr. Van Bonnet.
Yes, as a matter of fact, I do have an issue, and I would like to do that in closed session ex parte. And just before concluding that, the pre-trial brief once again is requested on the 30th of April. So in that case, we would be able to complete that, and if it is necessary to adjust it in a later stage, it's easy to work from that date on, and so forth. And for the status conference, if that would be somewhere in May, I'm very positive that people will try to attend, but procedural-wise, there needs to be done a lot, I think, for them. So that it would be useful that even with the client and everybody, we can confer on that day. So, for example, I don't know, 7th of May or something like that. It's maybe a useful date.
Thank you, Mr. Van Bonnet. Before I break, I'd like to ask the SPO if it considers that it's necessary to have another status conference in this case before transmission of the case to the trial panel or not.
Your Honor, it's up to Your Honor and the defense. If you wish to have such a conference, for instance, later on in April, we could, of course, consent to that. On our part, we don't consider it necessary, but if my learned friend insists, we would not oppose that.
Thank you, Mr. Prosecutor.
It's
Mr.
just,
Van-
Your Honor, that if there are issues that are coming up during this, then I can inform both the court and the SPO about it, and then we can move on from there. So it's to me, a kind of a closing status conference as far as I'm concerned. But if there's any matter that is to be raised, then it can be done on that part.
And would you like me to schedule a status conference before or after you file your pretrial brief? Would it be more useful before? After?
That would be useful, I think. If there is any issue related to that could come up, then we can discuss it.
Thank you, Mr. Fonboni. So we will do two things. Wait a second. So before we break, we're gonna reconvene after a short break of 10 minutes with the defense for an ex parte and closed session. Then we will have another break and we will reconvene in a public session with both parties, and I will issue a couple of oral orders at the end of this hearing. But now we have a 10 minutes break and we will be back in a closed session with the defense only as requested. The hearing is adjourned.
All rise. All rise. Please be seated.
Having heard the parties on the proposed calendar, I hereby issue an oral order with the following procedural calendar. By Friday, 16th April 2021, the defense is ordered to notify the SPO of its alibi and to disclose any relevant material pursuant to Rule 104(1)(a) of the rules. Should the defense need to seize the pretrial judge with a request for protective measures in relation to such material, it should do so by Thursday, 8 April 2021. By Thursday, 8 April 2021, the defense is also ordered to file any request for protective measures for non-alibi witnesses. In accordance with the framework decision on disclosure, and in order to allow the SPO to expeditiously respond to any such requests, the defense shall submit simultaneously a strictly confidential and ex parte, as well as a confidential redacted version of any requests for protective measures concerning alibi and non-alibi witnesses. The SPO may respond, if it so chooses, within 5 days from notification of the confidential redacted version of any such request. The Witness Protection and Support Office shall submit its risk assessments with regard to any witnesses for whom the defense seeks protective measures within 5 days of notification of such request. As the defense investigations progress, the defense may seize the pretrial judge or the trial panel, as the case may be, with further requests for protective measures. By Friday, 30th April 2021, the defense is invited to file its pretrial brief and related material under Rule 95(5) of the rules, without prejudice to any subsequent amendment thereof. And subject to the resolution of any outstanding matters, the transmission of the case file to the trial panel is hereby anticipated to take place on or around Friday, 7 May 2021. Further, I would like to organize matters in relation to the next review of detention by issuing the following oral order. The defense for Mr. Mustafa shall provide submissions on whether reasons for continued detention still exist by Thursday, 11 March 2021. The SPO shall respond to these submissions by Wednesday, 17 March 2021. Any reply should follow the timeline set out in Rule 76 of the rules. Before we conclude, and further in relation to the oral order I issued earlier today for the registrar to prepare a lesser redacted version of the transcript of the third status conference held on 14 December 2020, I hereby clarify that the closed session for the 14 December 2020 hearing is lifted, save for the redactions mentioned earlier on the record. I inform the parties that should they consider it necessary to hold a further status conference in this case, they are invited to submit a request to this end. At this point, I'd like to ask the parties whether they have any other issues they would like to raise. Mr. Prosecutor.
Your Honor, we don't have any outstanding issues.
Thank you, Mr. Prosecutor. Mr. Van Bonny.
Yes, Your Honor, we don't have any further issues.
Thank you, Mr. Van Bonny. This concludes today's hearing. I thank the parties and the registry for their attendance. I also wish to thank the interpreters, stenographer, audiovisual technicians, security personnel for their assistance. The hearing is adjourned.
All rise.